Will stand part. We now come to debate on the clauses, and the question is that clauses 1 and 2 stand part. Call Andrew Little.
Mr Chairman, thank you, Ross, to take another call. Mr Chairman, it's quite clear from the bill and from the debate we've had so far on it, and by the removal already, before we even come to the committee stage, of the word sustainability from the original bill as it was presented to Parliament, that this is not a bill about legal assistance at all. It is departed so vastly, so greatly from that original objective that it cannot possibly be described as a legal assistance bill in any measure at all. This bill is fiscally driven. It is about this government's desperate bid to drive down the cost of legal aid. We know that legal aid is expensive. It comprises a significant proportion of the Ministry of Justice budget, I think about 50%. That is a big chunk. But that's because legal aid plays a very important part in the life of our justice system. And I underscore justice, because without legal aid, knowing what legal costs are in this country, as they are in other developed countries, without legal aid, a large number of people would be deprived of the right of access to our justice system. They would be deprived of the right of representation. And so when we are considering matters of legal representation and the assistance that people need to get legal representation so that they can stand up and have their views heard in court and they can defend themselves, whether it's against the power of the state or whether it's against the power of other citizens who are well-funded and well-founded, then we should tread very carefully and very cautiously. And we should bear in mind that fundamental principle that there is no such thing as a justice system that shuts out a significant proportion of the population. We, as a developed country, celebrate our participation in, our adherence to, the principle of the rule of law. Now, I've talked about that before in this House, and that is absolutely fundamental to a developed country. In fact, it's one of the markers of a civilised and developed country, is that we observe the principles of the rule of law. And a fundamental principle of the rule of law is that all citizens have equal access to justice, which means that they have equal access to the institutions of justice, which includes our court system. And so when citizens are called upon to be in court because somebody else sues them, or they are in a situation where they have faced an injustice, it might be a consumer malfeasance, it might be a family matter, it might be a criminal matter, it might be a regulatory matter, and they are required to appear in court to argue their case or defend their position, then those who cannot afford legal representation must be given assistance to do that. That is a constitutional principle. It's not about private rights, it's not about the private realm, it is a constitutional matter that people caught up in private disputes and who must call upon the justice system, or if people are called upon to answer the powerful hand of the state, then they must be afforded proper support so they can be represented and be advocated for in court. Mr Chairman, the legal aid system we have at the moment already sets a very low threshold, in fact actually a very high threshold, but a low income threshold that enables them to get access to state assistance to be represented in court. $22,000 a year. There are a lot of people who are earning considerably more than that who would have great difficulty affording the legal fees that would be required to mount even a small or brief legal case. Even a plea and mitigation for a small criminal matter is going to cost a few $100s. And if you're on $30,000, $35,000, even $40,000 a year, an extra few $100s at a point in time in your earning year is going to be a significant burden. Those people don't have access to legal assistance. If it's a serious criminal matter, they may do. But the threshold, the income threshold that entitles a person to legal aid is very low. This bill compounds that situation when it comes to civil matters. And so the imposition of a $50 user charge to somebody who was on $22,000 a year, that is a significant obstacle. That is a huge burden. That is the difference between some food that week, or paying the power bill that month, or meeting other important costs. It might be a school bill or something like that. Mr. Chairman, $50 is a significant imposition to somebody on $22,000 a year, but this bill puts it on there. Then this bill also potentially levies other costs. When it comes to a care of children matter, then a person on legal aid may be required to meet the cost of counsel for the child if the court appoints a counsel for the child in a case in which they are involved. And they may have access to time payments. There may be means for them to do that, but that will be a significant burden on them, as it would be obviously to somebody on much less than $22,000 a year. The bill provides for debt collection measures. That adds to it, and that includes attachment orders, and attachment orders to the extent of 40% of their net income, their net weekly pay. That is a huge proportion of their pay, and that is enough to tip people over into absolute dire poverty. Mr. Chairman, this isn't about legal assistance. This bill might be more appropriately named the legal costs imposition of a cost burden on the poor bill, because that's what it will do. And in a desperate bid for this government to drive down the cost of legal aid, they have lost sight of the wood for the trees. What is an important constitutional principle, which is about access for justice, has got completely lost in their desperate bid to recover costs and make the government's books look better. And while no one would argue against proper fiscal responsibility in the management of the government books, we cannot overlook the important principle that access to justice will be put at risk for at least some people as a consequence of this bill. And so the title must reflect that. Mr. Chairman, legal assistance amendment bill simply does not speak to the reality of this piece of legislation, which is the imposition of significant hardship and a much greater burden on people who are at least in a position to bear that, and we're opposed to it for that reason.
I call Chris Farfoy.
Very much, Mr. Chair. Mr. Chair, the title and commencement debates for bills are usually an opportunity for members of Parliament to take some licence and have some fun with titles of bills. But in this instance, Mr. Chair, I'm certainly not going to do that because this is simply not a funny issue at all.